My name is Anthony Famularo. I'm an attorney for brands and creators. I help register and enforce intellectual property rights, or IP rights. And those IP rights can include trademarks, patents, and copyrights. In my last video, I provided an overview of the USPTO trademark application process. Today, I'm going to talk more about what to do when you receive an office action. Trademark law bars registration where the applied for mark is so similar to an already registered mark that consumers are likely to be confused, mistaken, or deceived as to the commercial source of the goods and/or services being offered. The most common refusal reason is that the applied for mark is confusingly similar to an already registered mark. Likelihood of confusion is determined on a case-by-case basis, and this is based on a variety of factors. In New York, these are called the DuPont factors. And while any evidence of record related to these factors must be considered, not all DuPont factors are relevant or of similar weight in every case. Still, there are generally two considerations involved in every likelihood of confusion analysis: comparing the products, comparing the marks. Recently, we had a client come to us with an office action in response to their trademark application. The client had prepared and submitted their own trademark application with the USPTO. And while the client used a popular service that allows you to prepare and submit your own application, the service did not catch the issues that led to the office action. The office action listed several reasons why the examining attorney had refused the application as submitted. In this case, the applied for mark was refused registration based on a likelihood of confusion to an already registered mark. In addition to a refusal based on likelihood of confusion, the office action also identified issues with the client's specimen of use. A specimen of use provides the required proof that the applied for mark is being used in commerce. A specimen of use must be submitted for each class listed in your trademark application. Most commonly, a specimen of use is made up of one of the following: a photo of the actual product bearing the applied for mark, photo of the product's tag, label, or packaging bearing the applied for mark, or a listing bearing the applied for mark, such as a website listing. In this case, the client submitted a specimen of use which showed the applied for mark on footwear. The class listed on the application was for exercise equipment. The examining attorney held that the footwear bearing the applied for mark did not constitute as exercise equipment. The client's office action listed a third reason for refusal. As a third refusal reason, the office action also required that the client disclaim part of the applied for mark. Specifically, the applied for mark included the word therapy. The word therapy was deemed to be merely descriptive and too related to the quality and characteristics of the actual product. And although the client ran into these issues, we were able to advise them on a plan moving forward that would address all the issues identified in the office action. Again, my name is Anthony Famularo, and I help register and enforce IP rights. If you have questions about your own trademark application or office action, contact me for a free consult.